Welcome to Estate Planning 101 video number 3. Today we're going to talk about who gets what if there is no estate plan in place. As I mentioned before, the power of your estate plan is that you determine who gets what. But if there is no estate plan, then you leave it up to state law. Here in California, when the community passes away, or if you are not married, if you individually pass away, then your estate, if it goes into probate, gets distributed through what they call intestacy. And the law is, if you're married, then it automatically goes to the other spouse, but if you both pass away, then it goes to probate, and then the intestacy laws determine how it gets distributed. So the first people it would go to would be your children. So a very, very important thing to note is that by married, I mean legally married. There's a very confusing law out there called common law marriage. Some people think that it governs here in the state of California. It does not. If you live with someone or are together with someone for 10 years, you do not automatically get some kind of, fake marriage that in the eyes of the law make you actually married. That doesn't happen here in California. So if you're not married, then the next person who would receive your property would be your children. Even if you have been living with someone or a partner for a certain amount of years, that would automatically go to your children. If there's no children, then it would be to your parents. If there's no parents, then to your siblings. And then if the siblings have passed away or they have their own kids, then it would go to nieces and nephews. So that's one thing that I want to clarify. Living with someone is not necessarily a marriage in the state of California. There had to be a legal document signed that said that you are married to them. So going into what that means is having the power to distribute your estate means that you would be able to determine how the property would be distributed upon your death. For example, if I'm married and I wanted to have that kind of control through my estate planning, I would say that my half of the community, which is if I'm married, would go into a trust that my spouse, who would be the person that's now alive, couldn't touch, and that it would go automatically to be locked in for the children. And the reason I say that, and the reason it's important to note the power of determining your estate planning is, for example, if my husband, who is now a widow, decides to remarry, then he essentially would not bring that money into his new marriage and take away from the kids that we had together. That's one of the very important things about having an estate plan, that you have the power to control what happens with your portion of the estate, whether or when you are passed away, even if the other spouse is involved. So the way I've set up my estate plan is I basically say you are not allowed to have control over my kids, my half, the money that I set aside for my kids, unless you signed a premarital agreement and you don't bring my money that I worked hard to build into this new marriage with this new spouse. So that's one of the benefits of having your estate planning, that you can have that kind of control and you can protect your kids even after you've passed away and your husband's moved on to some other person. Until next time, remember, don't die until you call me to set up your estate plan. I am Viviana Oropesa and I am your attorney in heels.